Matt Dolman, which is going to wow your minds because Matt has an amazing growth mindset. He's partners with Brent, and he's the founder of Dolman Law, co-founder Sibley Dolman with Brent. And I saw this in multi-million-dollar advocates forum under age 25. That's pretty cool. So that means you got a $2 million settlement under age 25. I think I read that correctly. That sounded a little crazy.
Yeah, 27, but I don't know where you got.
Okay, close enough.
I'll go with it. It sounds great.
Yeah.
By the way, before I get started, I'm going to say two things. Brent is my life coach. He's the one that's able to say no. I'm the one who says yes far too often. So he's the one that kind of reels me in all the time because I do use the a-hole meter as well. But I've signed up far too many a-holes in the past, and Brent's the one that weeds them out. So he's kind of the coach here. Two, I read Mike Morse's book, How to Fireproof Your Law Firm, and I can't wait to hear from him next week. That book should be read by every personal injury lawyer out there. Mike Morse, probably one of the 5 biggest firms in the country, runs a really quality shop. He's a real trial lawyer too, out of Michigan. And he's done a phenomenal job in building his firm and making it fireproof so that no matter what happens at the firm, no matter what comes up, it's almost automated. The firm is always going to spit out very similar results year after year. So today, well, as I get into this, I don't want to be boring. I don't want to get too far into the weeds in personal injury law and bore everybody that's on here that practices criminal law or family law. So the takeaway to start with is how to be proactive versus reactive. And I'm going to give you a few examples of what I'm doing in my practice. And I'm going to segue into calculated risk and how it's not necessarily mutually exclusive for moving quickly. All right. So to start off with, the thing that, the biggest mistake that I see other personal injury lawyers making out there, and I can tell you the truth, I did the same thing when I first started, is there's a threshold in personal injury law called maximum medical improvement. And a lot of lawyers wait until their client reaches that threshold before they send out their demand to the insurance company. And what happens is you lose your leverage with the carrier. You have to move quickly in personal injury law. These cases, unless the client is having surgery or sustained a catastrophic injury, these are depreciating assets. The cases actually lose value over time. So the rule at our firm with Brent, as we joined together in the past year, 2 years now actually, and in my firm, Dolman Law Group, and we're merging into one firm called Sibley Dolman, is that if the case is not resolved within 5 months, and there's extenuating circumstances such as, the client get pregnant, we've had a few clients have been incarcerated, believe it or not, or clients have comorbidities and other medical issues that are not related to the accident or incident. But absent those situations, we're trying to get the case out of our office within 5 months, or we're litigating the case. And the reason being is that the longer this case drags out, the more likely you're going to be in mediation a year and a half from now, 2 years down the road, and your client has not treated medically for a year, year and a half, gigs up, game is over, you played right into the insurance company's hands, they know there's no future damages, and you've capped out the amount that your case is worth. Plus, the longer the case drags on, the case reaches an apex where it is at the absolute top, the pinnacle of what the case is worth. The longer you go on with that case, you run into the problem. The clients are, they're going to incur more medical bills while the case is not increasing the value commensurate with the amount of time spent on the case. So therefore, they're walking away with a lot less money, and it's less likely they're ever going to refer you a case again or leave you a positive review. They're going to walk away dissatisfied. So you never want to play into the carrier's hand. You want to move these cases as quickly as you possibly can within reason. So at Sibley Dolman, what we do is we send out demands from day one, literally. As soon as our client has an MRI, which is usually within the first 30 days, we're submitting our demand. And the goal is, and I don't want to get too far into the weeds. And if I am, please tell me that and I'll shut up. But the goal is we want the insurance carrier to set the reserves, which is the amount of money that the adjuster has been allocated from management to put on the case. Not necessarily what they're going to pay, but what they have, the ability that they have, the ceiling, if you will, of what they have to pay on the case. So we want to get the demand out early. Then we want to supplement that demand as early and as often as possible with updated medical records. We want to treat every case as if it's the only case in our office and let the insurance company feel like, we're getting 9, 10 letters from Sibley Dolman on what we think is a garbage case. Maybe it's not garbage. Maybe we should take a second look at this case. Maybe we're missing something. That is the mantra. How we handle cases at Sibley Dolman is moving quickly and working on leverage. because you lose leverage over time. Now, I talked earlier about calculated risk. Right now, nationwide, and I've talked to some of the best trial lawyers out there, elite guys. We have one that's board certified at our firm, a number of guys I've talked to in Tampa Bay and South Florida area, and other guys throughout the country, a friend of mine in Chicago, a couple of guys up in Michigan. They're having the same problem with the same insurance company. And it's called Progressive. We dealt with the same war a few years ago with State Farm. So right now, COVID is the greatest thing that ever happened to the insurance industry. Last quarter, Progressive operated a $3 billion surplus. They returned $1 billion to the policyholders. They made $2 billion. There's a lack of claims, less cars on the road, and there's no jury verdicts. There's no trials right now. So this is playing into the insurance company's hand and why they're giving grossly disproportionate offers. On a good day, insurance companies give bad offers. It's their incentive. But right now, Progressive is giving offers of, let's say, $10,000 in a case is worth $60,000 or $70,000. So I'm going to tell you right now how to make your cases worth a lot more money. And even if you don't practice personal injury law, hopefully this translates to how you handle your files or how you handle your firm by being proactive and taking the calculated risk. If you settle 60 cases for, let's say, $15,000, you're looking at $900,000, and that's $300,000 in attorney fees. Instead, you want to file suit on all these crappy offers you're getting from Progressive Insurance Company and the host of other insurance carriers out there. These cases are going to multiply in litigation. Now, litigation is a risk. You're going to spend money on filing fees. You're going to spend money on summons, process servers, discovery, retaining experts, what have you. But down the road, you're going to get those case costs back when you get the case resolved, either at mediation or if you have to take the case to verdict. And you got to take some cases to trial. If you aren't, there's no bite behind your bark. At our firm before COVID, the goal was to try 5 to 7 cases a year, no matter what. Now, if you take the same 60 cases and you get them to $60,000 on average per case, you're looking at now $3.6 million, and your average fee, based on the 40%, is $1.4 million, as opposed to walking away with $250,000, $300,000. You took the risk. You're going to wait a while before you're ever going to recoup that money, and there's no guarantee that some of these cases might go south. But on average, you're going to make a lot more money for your firm, but better suit, you're going to do a lot better job for your client. You're not going to leave money on the table, which is, it's cowardly as a lawyer. You're taking on these claims, and it's scary out there. There's a lot of personal injury lawyers, a lot of settlement mills that just take in volume. It's a garbage in, garbage out mentality. If you move these cases and you take the calculated risk of litigation, you're going to wind up making a handsome profit at the end. Your clients are going to be happy. They're going to give you better reviews, which will make you appear more prominently in Google Local, as Bill will explain to you. You're going to do a lot better job for your firm, your clients, and overall your profession.
So when we talk about making fast decisions, which, I see what you're talking about on the calculated risk side. How do you have a mental framework when you're making decisions that you, like, maybe it's a checklist or like a mental checklist of sorts where you balance urgency with calculation so you can make fast but good decisions in all facets, not just, going big on cases, but all facets of decisions?
Is it going to do a better job for the client? Am I going to make more money for the client? Am I going to return a better result for the client? Because if I am, that's going to be my decision moving forward, because it'll all come back and pay in dividends. The other framework is I run everything by Brent. Then Brent says yes or no to me because I move too quickly. He'll tell you that. Speed is important, but then you have to have a partner who has some reason to them and some sanity, because I'm the crazy one, and Brent kind of reels me in and makes sure that I don't make insane decisions. If you
okay. So I guess I'd like to hear Brent kind of chime in, because it seems like you guys are, since you're partners, maybe Brent knows things about you that you wouldn't state right now. So where do you see Matt's aggression in making fast decisions as a huge benefit? And how do you see him leverage this?
Yeah, I see there's a lot of stuff that comes up in a day-to-day. I mean, and I'm talking like maybe even the super majority, 90% of things, where either decision is perfectly fine, and really the killer is indecision. And then your people that work with you start to see you as indecisive. To-do lists continue to get unchecked off. Whereas both options are perfectly viable as long as they're done with confidence. And I see this a lot. People have just, paralysis paralysis. And that's something that Matt does not suffer from whatsoever. So a lot of times when you need a quick answer and you need a decision on which way to go, you can go to Matt and he'll give it to you and you're on to the next thing. And speed is just so important with that. So that's a huge thing, especially in high level strategy and litigation.
And would you say that the fact, so I had a question I was going to ask you guys really quick, which I'm going to transition to right now, because I think the growth you guys are preparing for right now could be largely due to you guys finding a really awesome partnership between each other. And a lot of lawyers on this call, I think, would like to hear, you guys both, weren't partners together at one point. Now you are. What are the pros and cons of partnership? And what are some habits you guys use to keep each other in check and maybe resolve conflict so that, you guys don't, become unproductive disagreeing with each other? Like first question is pros and cons. And then the second is habits you guys have formed working together.
I think, the pros and cons of the partnership are, obviously you have a partner, right? So you have to run things by your partner. But on the flip side, you get to run things by your partner and you get an extra pair of eyes and ears on every decision that you need. Now, I think the most important part of the partnership, and to some extent, we were guilty of breaking this rule early in our partnership 3 to 4 years ago. The most important thing, without a doubt, is for the partners to have a very clear understanding of each other's turf, so to speak. And I don't mean that in a territorial sense. I mean it in like a division of labor. I have only so much bandwidth in my mind. Matt only has so much bandwidth in his mind. This is the stuff that always is on my mind when I'm in the shower. This is the stuff that's always on Matt's mind when he's in the shower. And I don't have to be preoccupied with, is our search engine rankings keywords this month being done properly? I know for a fact that's what's on Matt's mind. Whereas Matt doesn't have to worry if our phone system is being handled efficiently enough and if the call transferring from the call center to the web chat to the referral partner back to the local attorney is being handled properly, because he knows for a fact that I'm obsessed with that stuff and that's what I'm working on. So
it's almost like you guys are outsourcing worries to each other, right? Because we have this saying, it's like there's a different level of energy, founder level energy, and then like non-founder energy, which is hard to simulate through incentives and bonuses and blah, 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 blah. So it seems, and I always say this to my team in frustration sometimes, is I just want to feel like you're worrying about X, right? And oftentimes I complain about the expense side of the business because I'm very not focused on that. So then sometimes I'll get frustrated and I'll go, can't someone just worry about our expenses like I would for like my own money coming out of my own bank account? And oftentimes it's like, yeah, we can, but we're not like, so what I'm noticing here is that you each kind of in your own niches in the firm feel like, well, Brent's going to worry about this all day, every day. Matt's going to worry about this all day, every day. And you trust that with that, you're each going to create solutions where you don't have to micromanage each other.
Mm-hmm. Correct.
Absolutely.
So if you read Gino Wickman, you're going to hear a lot about him from Mike Morse. Gino Wickman's a consultant out there, and he wrote a few different books, and he talks about visionaries versus integrators. Brent is more of the integrator, deals with the daily tasks. I'm more of the big picture guy, and sometimes Brent has to rein me in, which is why we complement each other so well. I'm more big picture items. Brent is more of just making sure these tasks are implemented correctly and working within an actual system. Because left to my own devices, I'm so ad hoc that there wouldn't be a system and it would just be absolute chaos.
You know what I sense is such self-awareness from you guys. Because most like you see like the ego, caricature of a lawyer, and it's like every lawyer would want to be the visionary, right? But it seems like, I just saw Brent's head nod and go, yeah, I'm more of the integrator. and it didn't seem like Brent tried to like justify, no, I'm a visionary too. And it's like just cool to see this self-awareness. Do you think that this is something you each had through your own practices before you became partners? Or is it something you guys had a conversation about? Like, I want to be the visionary, Brent. Or was that never like a conversation that you guys had, or was it just coming in something that happened?
It happened based on Brent. We were successful in spite of ourselves for marketing, and you could talk more about what I've done with my website, and I can talk about what Bill's contributed to us as well, and we're working together. But our marketing was so successful, we're bringing in so much work, and I was focused on litigation. We were doing very well as a firm, but I was doing well in spite of myself and the lack of systems. And partnering with Brent has made the firm a lot more streamlined and a lot more successful. I'm able, especially when with COVID coming out now, weaknesses are so much more glaring if you haven't taken care of and shored up your issues at your firm. Margins are so much tighter now. So Brent has made this firm, I wouldn't say we're fireproof, but we're getting pretty close to that. It's a very smooth operation as compared to when I was running it on my own. It was more ad hoc. We were successful in spite of ourselves, but it's a lot better now. And I sleep easier at night knowing that he's there.
Aww.
That sounded a little, yeah, and that's not me. Let's take that back. That's where we have all the boxing pictures here. It's a little bit more masculinity. Boy's bedroom. But yeah,
he's
Brent
quickly recovering from that.
And trust me, the best partnerships is as soon as I get everything nice and stable and functioning efficiently, Matt's job is then to break it all and try and get to the next level. And then I have to go and fix everything again at that new level of scalability, and then rinse and repeat.